How do non-compete clauses affect Americans working in Europe? Imagine moving to Europe for a new job and suddenly finding yourself restricted from working in your field after you leave. That's what non-compete clauses can do. These are parts of employment contracts that limit your ability to work for competitors or start a similar business for a set time after leaving your employer. They are common in many countries but are handled differently across Europe. In Europe, non-compete clauses are recognized but usually have stricter rules than in the United States. Typically, these restrictions last between 6 and 12 months, not several years like some U.S. agreements. They are also often limited to specific geographic areas, such as a city or region, to avoid overly restricting employees. Employers must show a clear reason for the clause, like protecting trade secrets or maintaining client relationships. One important difference is that European laws often requiring employers to pay employees during the non-compete period. This compensation can range from 30% to 100% of the employee's previous salary. The idea is to balance the restriction with some financial support, making it fairer for the worker. European countries tend to interpret non-compete clauses narrowly. If a clause is unreasonable or too broad, courts are less likely to enforce it. For example, in Germany and Belgium, employers must pay workers during the non-compete period for the clause to be valid. In the Netherlands, non-compete clauses are easier to include but might requiring costly legal challenges to contest. For Americans used to the United States, where non-compete agreements are often banned or heavily restricted, working in Europe means understanding these stricter rules. The United States Federal Trade Commission has recently banned non-compete clauses for many workers, but this does not apply outside the country. In Europe, these clauses are still allowed but with clear limits and the requirement of compensation. If you are planning to work or already working in Europe, it's smart to review your employment contract carefully. Look at how long the non-compete lasts, where it applies, and whether you will be paid during that time. It's also wise to seek legal advice in the specific country to understand if the clause is enforceable. European laws often give employees stronger rights to challenge unfair restrictions. Keep in mind that European employers must justify the need for a non-compete clause, and they cannot use it to unfairly block competition. If a clause seems unreasonable, you might be able to challenge it in court. Many European countries also requiring employers to pay a fair amount during the non-compete period, providing some financial protection. Overall, Americans working in Europe will find that non-compete clauses are more regulated and tend to favor employee rights. This means you have better chances to challenge unfair restrictions and receive compensation if such clauses are enforced. Being aware of these differences helps you navigate employment contracts smoothly and avoid surprises. Understanding these rules can make your experience working or living in Europe much more straightforward and secure.